Morning.
Morning.
I see there is a difference in the panel. I think Judge O'Leary was supposed to be on this, and you're Judge Feibel, right?
Yes, I am.
Yeah. You actually swore me in as an attorney.
Well, that's great.
And I take my oath of office very seriously. So the reason I'm here is because...
Before you start, I just want to make sure you're aware, because I just talked to the clerk. You have 30 minutes.
Yes.
And because there's no respondent, there's nothing to reply to. So you'll have 30 minutes straight, if you wish.
Okay, yes. Well, I'm here because the decision by Judge Marginis in this case has to be reversed, and this decision does not comply with either the law or the facts of the case. I would like to start with the fact that in his ruling to dismiss the case, Judge Marginis has stated that I have filed the case prematurely, too early. During the court hearing, it's ironic that he was stating, the case deals with two issues. One issue is 1.5 million invalid voter registrations. And I have here in the audience an expert who was a relational data analyst for NADA, North Atlantic Treaty, who has come up with this information. I have received a certified copy of the voter roll from the Secretary of State. He has reviewed it, another expert has reviewed it, and we have found actually 1.5 million invalid voter registrations. We found thousands of voter registrations of individuals who were born in 1850. 1850. I mean, you weren't even born when those people were already voting.
That's true.
And what's interesting, they're still voting. They're still voting today, all of them by absentee ballots. And we know that the oldest person in the United States today is about 113 years old. Those people are 163 years old and in good condition and still voting. That might be actually a good argument not to change our health care system. Apparently, it's very good. Morning. I see there is a difference in the panel. I think Judge O'Leary was supposed to be on this, and you're Judge Feibel, right?
Yes, I am.
Yeah. You actually swore me in as an attorney.
Well, that's great.
And I take my oath of office very seriously. So the reason I'm here is because...
Before you start, I just want to make sure you're aware, because I just talked to the clerk. You have 30 minutes.
Yes.
And because there's no respondent, there's nothing to reply to. So you'll have 30 minutes straight, if you wish.
Okay, yes. Well, I'm here because the decision by Judge Marginis in this case has to be reversed, and this decision does not comply with either the law or the facts of the case. I would like to start with the fact that in his ruling to dismiss the case, Judge Marginis has stated that I have filed the case prematurely, too early. During the court hearing, it's ironic that he was stating, the case deals with two issues. One issue is 1.5 million invalid voter registrations. And I have here in the audience an expert who was a relational data analyst for NADA, North Atlantic Treaty, who has come up with this information. I have received a certified copy of the voter roll from the Secretary of State. He has reviewed it, another expert has reviewed it, and we have found actually 1.5 million invalid voter registrations. We found thousands of voter registrations of individuals who were born in 1850. 1850. I mean, you weren't even born when those people were already voting.
That's true.
And what's interesting, they're still voting. They're still voting today, all of them by absentee ballots. And we know that the oldest person in the United States today is about 113 years old. Those people are 163 years old and in good condition and still voting. That might be actually a good argument not to change our healthcare system. Apparently, it's very good. We have 163-year-olds who are still voting in each and every election. And another issue is the issue of invalid IDs for Mr. Obama. I have provided the court with expert opinion. One of them was opinion of a former chief investigator for the U.S. Coast Guard that stated that Mr. Obama's selective service certificate is invalid. I provided them with Mr. Obama's own biography that he himself submitted to his publisher, Dist, and he stated in his own biography that he provided to his publisher in 1901 that he was born in Kenya. I have provided actually excerpt of the Parliament of Kenya Assembly, which was March 25th, 2010, where they stated how else, they were talking about pluralism in the United States of America and saying how else a man who is not even a Native American, somebody who was born right here in Kenya, could become U.S. citizen. I have provided Mr. Obama's own school registration from Indonesia, where it shows that everything that he is stating about himself is not true. When you look at his school registration under citizenship, it says Indonesian, not American, Indonesian, where it's as his last name, it states Soetoro, and that's the last name of his stepfather. As we know, his mother remarried, and he went by the last name of his stepfather. And he also states his, like during the elections, he was stating his religion is Christian, and that says his religion is Muslim. So we can see that everything that he is stating about himself is simply not true. I also provided the court from his mother's passport records, certified passport records that came from the Department of Justice, where he was removed from his mother's passport, I believe it was in 1969, and there is an explanation. When a child is removed from the mother's passport, when he gets allegiance in another country, and that was in Indonesia. So there are over 100 pages of records showing that Mr. Obama is still a citizen of Indonesia, that using expert opinions that he is using a birth certificate that represents a forgery, not a valid birth certificate. His selective service registration contains a postal stamp, which is a fabricated postal stamp. I mean, those are very serious issues and had to be heard. Judge Martinez, during the court hearing, stated, well, you're just taking information from the internet. And I stated, no, I'm not getting information from the internet. I'm providing you with sworn affidavits from experts and top law enforcement officials, among them also Sheriff Joseph Arpaia. And it's interesting that in his opinion, Judge Martinez stated that one of the three reasons that he stated that he dismisses the case is that I filed it too early. How did he figure that out? He himself went outside the record and he looked on the internet. He was the one who went outside the record, looked on the internet. He found some website and he quoted this website in his opinion. When I went to this website, it says code 404 not available. It's not even available. Nobody can even verify where is he getting this information. And I personally checked with the Secretary of State. I called, I was told July 3rd, end of canvassing, you have 5 days, which would have been July the 8th, the 5th day, which was Sunday, and I filed properly on July the 9th on Monday. So that was simply incorrect. It was error of fact by Judge Martinez. Next issue, he stated that I did not serve the parties properly and that I did not serve them timely. Well, this is absolutely not true. I mean, it's appalling that Judge Martinez would even state this. Either he did not bother to go through the file, look through the file, or he simply was, for some reason, stating things that are not true. He had in front of him the certified mail receipts. This one is for Barack Obama, that he was served on July the 10th, and the record provides not only all of the defendants were served served by certified mail, and copies of the certified mail receipts were provided. But also, I have paid, and I'm doing this case pro bono because I do take seriously my oath of office to support the Constitution, and that's why I am doing constitutional law pro bono. So what I did, I provided receipt, actually 2 receipts from same-day service in Washington, D.C., and you can actually see I paid out of my own pocket $125 every time. Twice I paid $125, and he has it. This is one, and this is another receipt. So he was served on July the 10th, then he was served again on October 26th, and then he was served third time on October the 31st. They delivered. So there are certified mail receipts. Moreover, and in the file, you can see also certified mail receipts that Dianne Feinstein was served and Elizabeth Emkin was served. Moreover, attorney for Dianne Feinstein, Mr. Lars Olson, has called me and asked me, well, what's this case all about? And I told him, and he said, can you please email me the pleadings? And my assistant, Yulia Yuns, emailed him the pleadings, and you can see in the file there is a sworn declaration, sworn affidavit, notary sworn affidavit from my assistant, Yulia Yun, who is stating, I personally talked to Lars Olson, attorney for Dianne Feinstein. He asked me to forward to him the pleadings by certified mail, which I did, and she provides the name of the firm and the email address that he gave her. Where would I get the email address? I didn't know who was her attorney. I didn't have her email address. He called us, and that's how we served. So we served certified mail. We also provided Mr. Lars Olson, her attorney, with the pleadings and summons. And later on, I have here a volunteer, Mr. Goffin, who is just a patriot. He personally went to Dianne Feinstein's office, and you can see not only his signed declaration of process server, and Judge Margin is mistaken. I did submit signed declaration. It is in the file, and I submitted it with excerpts of record. He signed it, and he also attached a letter where he stated that he personally, and he can confirm that, he personally went to her office. He drove there, had the package to serve her yet again during this hearing, so that to make sure that she has an opportunity to respond during the motion hearing. And her assistants asked, who is it from? And when he said from attorney Orly Taitz, she refused to accept. She said that Dianne Feinstein does not want to accept any packages from attorney Taitz, and you need to send it by mail and by fax, and he did both. And you can see in your packet that she was served both by fax and by certified mail, yet again by Mr. Goffin, and through her attorney, and by me by certified mail. Same with Ms. Emkin. She was served by certified mail, and again Mr. Goffin is here, and he served her personally. He drove to her house and hand-delivered the papers, and you have certificate of server. So what Judge Martin is stating, he said that he wants to dismiss the case because he believes that the defendants were not properly served in the period of 4 months. That's absolutely not true, and you have all the evidence to see to the fact that it is simply not true. Further, he is stating that I have filed here in California, I'm sorry, in Orange County, and I should have filed in Sacramento. Wow. And actually, I have provided with my appeal quotation, and it's statute 39 from the California Code of Civil Procedure. It's 396B, which states that no petition should be dismissed if the court finds that it is filed in the wrong court. It needs to be transferred to another.
Why don't you read the whole statute?
Yes. Yes. Here it is. California Code of Civil Procedure states 396A. No appeal or petition filed in the Superior Court shall be dismissed solely because the appeal or petition was not filed in the proper state court. So again, Judge Marginis made an error of law and fact. if this was filed, if he believes that this was not a correct court, then he had no right to dismiss it. He had to transfer it to correct court. Further, the complaint, the petition was filed under several statutes. Excuse me. It is filed under statutes 16100, 16101, 16420, and 16421. And as a matter of fact, Judge Marginis states that only under statute 16421 it has to be filed in Sacramento. However, there are 3 other statutes that he doesn't mention. Even if it would have been filed in the wrong court under statute 16421,